before we rushed in with NADON, but hadn't disposed. So they're basically using the same rationale about the architecture of our Constitution and the amending formula. They sent a very clear message to this government, not just this government, but any government, that there are certain basic structures to the Constitution that you can't just unilaterally and fascistically decide you're going to overrun. And basically, these two cases are the only cases since 1982 that the Supreme Court has interpreted the amendment formula to the Constitution. And so now that's done. And it's pretty clear that anything that's mentioned in Part 5 of the Constitution Act, the Senate, the Supreme Court, and the various other things cannot easily be changed unilaterally. They cannot. But the court went even farther and said that the structure of the Constitution is not limited to those specific things mentioned in the text of the Part 5 of the amendment formula, but applies to what they called, quote, the architecture of the Constitution. So a lot of the old principles that they had read in prior to the patriation are also equally protected, which is exciting because that means, you know, there are certain things that are not specifically mentioned there that if they speak to federalism or democracy or respect for minorities, rule of law, and constitutionalism, which are the 5 principles that they enunciated in the Quebec secession reference, those two cannot be so easily overridden. They talk about the basic structure of the Constitution, which is funny because, not really funny, but because they seem to be going 50 to 75% the way of the Indian Supreme Court in 1974. In 1974, the Supreme Court in India went as far as to say that you couldn't override the basic structures of the Constitution even if you amended the Constitution, because once that democratic contract was made, it's implied that you cannot unmake that democratic contract. So the Indian Supreme Court 40 years ago brilliantly said, when it comes to basic rights, the basic structure of the Constitution, even if the governments got together and said, let's undo that, you can't do that. And so you see very similar language now in the Senate reference and the Quebec secession reference and the judge's reference that we brought, that we argued in and we had initiated with our federal court application to stop this appointment, which was clearly contrary to the Constitution. So that's, for me, is exciting, you know, in the sense that they've entrenched and said, this is the deal we have. You can't really derail the train unilaterally. So that's a very good sign. So ironically enough, we'd set this meeting a few weeks ago, but with respect to our case in the federal court, the second level, the Justice Russell, who heard the appeal from the protonotary, who struck the entire action for not being justiciable, made his ruling yesterday. I got it late Thursday night, but I saw it yesterday, and I analyzed it for the purpose of this meeting. I have here 25 double-sided copies of the ruling, if anybody wants to take one. And then I have I didn't know how many people would be here, but I have a single side. I'll leave with Anne if anybody else wants a copy. Maybe you can see to it, Anne, that they get it. And I'll talk briefly about it. There's a bit of bad news, but mostly good news. The bad news is that we all knew we'd have to go to the Court of Appeal. The government lawyer is out of town till May 8th, so I haven't been able to speak with them to see if they're appealing part of the ruling. On the issue of whether or not the declarations that we sought to say that the government and the finance minister were exceeding the parameters of the Bank of Canada statute and the Constitution, Justice Russell said those are justiciable. They can proceed with those. You know, the courts decide this all the time, And the court's not going to be deciding whether the particular minutia of their socioeconomic choices are to be reviewed, but whether or not they're staying within their statutory or constitutional parameters. And so that's the good news, because the lower court had completely struck it on the basis that nothing was justiciable, and he's reversed that ruling. And if you recall, basically that was the main thrust to our challenge, is to get a declaration and a clarification of whether or not they're properly following the statute and the Constitution in exercising the powers of the Bank of Canada. Justice Russell agreed with me that when the protonotary interpreted the may as not giving rise to a duty, that was beyond his jurisdiction to do. He said that has to be for the trial judge after evidence goes in. So I'll briefly go through the decision and explain what the ruling was, and then I'll take questions. I'll take questions from anybody who has any. Let me say, in fairness to this judge, who is a very intelligent and capable judge, that most of his, I'd say virtually all of his setting out of the facts and the issues are really fairly done. So at paragraphs 1 to 13, pages 1 to 9 of the decision, he accurately sets out what the claim and the relief sought is, and he doesn't pull away from basically setting out what the plaintiff's allegations are with respect to how they've hijacked Canada's financial agenda and Canada's sovereignty. So he sets that out. Many other judges might have simply held back and not elaborated on the facts of what the allegations are, knowing that the decision is going to be published and is going to be out there. But the court didn't do that. If you read it for yourself, you'll see that there's a fair recital of what we're asking for and what the allegations are. And then he fairly sets out what the decision of the protonotary was down below at paragraphs 14 to 23, pages 9 to 13 of the decision. And then he goes through the scope of review, and then he sets out the statutory provisions, and then he sets out the arguments at paragraphs 29 to 44 that I made, and at paragraphs 45 to 62, the arguments that the government lawyer made. And again, with the exception of one minor detail, these were also fairly set out accurately, which, it may be surprising to you, sitting there thinking, well, what's the big deal? Isn't the judge supposed to do that? And most judges don't do that. Because then they can go off and decide an issue that wasn't really argued. This judge actually stuck to the rigor of his duty and actually did that. The only minor flaw in his recitation of the facts is that he cites the protonotary in saying that you can't have a discrimination claim when all Canadian citizens within Canada are treated alike. And I made it very clear, and it's clear in the pleading and during argument, that not only are Canadians discriminated against with respect to private foreign bankers, but they're also discriminated against with respect to private domestic bankers too, who loan money to the government at interest rates that we shouldn't be paying. So apart from that, his review of the facts, the allegations, and the arguments are fairly accurate. Then he goes through his analysis, and he starts his analysis at paragraph 63 to 97, pages 37 to 56 of his ruling. He starts out by saying that neither I nor the government lawyer disagree on what the law on a motion to strike is, which is true. It's just that we disagree on whether or not it was properly applied in this case. So then he goes to the first issue of justiciability. And if you recall, justiciability is an issue that the courts look at to see whether or not the court has the wherewithal or the capacity to look at the legal issue. Throughout the decision, when he says Bank Act, he doesn't really mean the Bank Act, which is separate from the Bank of Canada Act. He's referring to the Bank of Canada Act. And Section 18 in particular had to be read in a permissive way. The obverse of his reasoning would seem to suggest that if the act contains a, quote, legislative imperative, then this may well be justiciable matter for the court. The full import of the Act and what it requires of Canada and those ministers and officials who act or don't act in accordance with the Act is at the heart of this dispute. Hence, in order to reach his conclusions on the non-justiciability, the protonotary decided the principal legal issue at stake in these proceedings. I do not accept the plaintiff's argument that statutory interpretation cannot be dealt with on a motion to strike, and then he cites a federal court case. To strike, and then citing a federal court case, he could have cited the Supreme Court cases, which he later does. He says, however, it may be better to leave a complex matter of statutory interpretation for argument at trial, and the fact that an issue is contentious does not necessarily make it complex. Protonotary Alto felt that, quote, may in Section 18 had an obvious literal meaning that could be dealt with on a motion to strike. My reason for differing from the protonotary on justiciability is that in addition to breaches of the Bank Act, the claim is also based upon other alleged constitutional breaches, and even if Section 18 of the Act is permissive, this does not dispose of the allegations of improper handing off to international institutions. May is usually permissive, but this is not invariably so, and full legal argument on a full evidentiary record is required before the court can decide what the Bank Act requires of the government and those involved in applying and interpreting that statute. And then he cites the Supreme Court of Canada case in Vermont, which I put before him, saying that issues as to the proper interpretation of relevant provisions and the effect upon them would appear to be better determined at trial, where a proper factual case can be laid. And in paragraph 73, citing another Supreme Court case in empirical tobacco, he says, the question is whether, considered in the context of the law and the litigation process, the claim has no reasonable chance of success. It meant to encourage the court in a motion to strike to decide points of statutory interpretation before hearing the evidence and full argument based upon that evidence. It may well be, however, that at some appropriate time in these proceedings, this important matter will lend itself to summary determination. What he's saying is, if you have the facts required, it doesn't have to be a full-blown trial. He's not determining that. You can determine this up the road, but not on this preliminary juncture before on a motion to strike. Then in paragraph 74, he says, in addition, as I think the claim makes clear, the plaintiffs clearly dispute and challenge certain socioeconomic policy decisions that have been taken by the government and others with respect to the Bank Act. It is also clear that plaintiffs would like the government and others to make policy choices that are more in line with the plaintiffs' views of how to interpret and apply the Bank Act. In my view, however, the principal relief sought in this claim, the declaratory relief, does not require the court to adjudicate competing policy choices. It requires the court to assess whether Canada, the ministers and the officials identified have acted and continue to act in accordance with the Act and their constitutional obligations. In other words, there is, in my view, a sufficient legal component to the claim that will allow the court to assess government action against the Bank Act and the Constitution without having to review policy. By that he means the nitty-gritty. And then paragraph 75, he says, the difficult boundary between what a court should and should not decide will arise time and time again in a case like the present. However, the issue is not whether the court should mandate the government and the bank to adopt economic positions espoused and advocated by the plaintiffs, nor will the court be deciding whether a particular policy is financially or economically fallacious, although this accusation does appear in the claim. In my view, the court is being asked to decide whether particular policies and acts are in accordance with the Bank Act and the Constitution. If justiciability is a matter of appropriateness, then the court is the appropriate forum to decide this kind of issue. In fact, the court does this all the time. The Supreme Court of Canada has made it clear that the Parliament of Canada and Executive cannot advocate function. See Wheat Board. These are the old World War II War Measures Act cases that I put before Justice Russell. And he also cites the Quebec secession reference, saying that the executive and other government actors are bound by constitutional norms. And then finally, paragraph 76, he says, so as regards the declaratory relief in the claim, it is my view that the matters raised could be justiciable and appropriate for consideration by the court. Should the plaintiffs stray across the line into policy, they will be controlled by the court. There's a difference between the court declaring that the government or the governor or the minister should pursue a particular policy and a declaration as to whether the policy or policies have pursued or are compliant with the Bank Act and the Constitution. The facts are pleaded on those issues. Subject to what I have to say about other aspects of the claim, the plaintiff should be allowed to go forward, call their evidence, and attempt to make their case. It cannot be said, in my view, that it is plain and obvious on the facts pleaded that the action cannot succeed as regards this aspect of the claim. And even if Section 18 of the Bank Act is interpreted as purely permissive, that does not decide the issue raised in the claim that Canada has obviated crucial aspects of the Bank Act and has subverted or abdicated constitutional obligations by making itself subservient to private international institutions. Okay? So on that score, we won, which is 75 to 80% of the claim, because what the important issues in the claim are the parameters, the statutory and constitutional parameters of the government with respect to the bank, and what kind of marching orders they're taking from private individuals, and whether or not that's an application of the Constitution. That's what we want to really pursue. Then he deals with the tort claims for damages and the charter issues. He says those are not detailed enough, and he's striking those. So, but in striking them, he again overturns the protonotary, because the protonotary says, I'm striking everything, but they don't have a chance to redraft the claim with respect to that. He says, I'm striking those, but they can also come back a second time and try to make their case better. Whether we do or not, this judge is extremely sharp, because if you go to paragraph 90, he says, he envisages that we may not come back with those claims. He says, in paragraph 90, he says, it seems to me that the fundamental problem of how the plaintiffs can simply come to the court and request declarations that their interpretations of the Bank Act and the Constitution are correct is the reason why they have attached tortious and charter breaches to their claim. They know that they need to show that how individual rights have been infringed, but as of yet they have not set out in their pleadings how their own rights have been infringed, let alone the rights of all Canadians. So what the court said was, declaratory relief can be brought. The charter claims and the claims for damages, which are really secondary, aren't properly pleaded, but they can try to plead them again if they want. So then, on the last two issues, so we have justiciability, which is the basis upon which the whole claim was thrown out, overturned. On the last two issues, jurisdiction and standing, he says in paragraphs 82 to 91 that, well, jurisdiction, I'm not really going to decide here. The protonotary said there was jurisdiction, but I'll just leave it. I'm not going to prejudice the government's ability to come back on jurisdiction. Let's see what the new statement of claim looks like. And then he says, standing, by striking the tort and charter claims, the plaintiffs don't have private party standing, meaning without the charter claims, they're not personally affected. But I agree with the protonotary said they pretty well may have public interest standing. So all we care about is the public interest standing with respect to the constitutional declaration anyway. And so, but he said, but I'm just going to strike the whole thing. You can pursue the declaratory relief. You can try to re-pursue the charter and tort claims. And once you have, we'll see where the jurisdiction and standing issue on a private basis is. Now, this is where I, with due respect to his judgment, I think this is where he made an error. I understand why it's not an error in this sense. Administratively, it makes sense, because if you only strike certain portions and leave the rest of it intact, when you amend, it's a mess. You have to underline the new portions, underline the portions you're deleting. You have my ruling. You can pursue the declaratory relief, redo the charter claim, and so you get a nice clean document coming back in. And if the government has a bone to pick with it, they can come back, but they can't re-raise the issues already determined unless they appeal those issues. Okay, so we're left with, we can pursue the declaratory, the statutory and constitutional relief. We'll have to redraft the tort and charter claims. And so what really is up in the air now, he's given us 30 days, or in his order he says, normally how these things go is they're extended, but he says we have 30 days unless otherwise extended by the court on the advice of counsel. So usually if there's an appeal, you don't do the new claim because the Court of Appeal alters the judgment, then you don't have to do it a third time. So where we stand is the government may appeal the ruling, in case we can respond, and if the government doesn't appeal, we can do one of two things. Simply redraft the claim. My view is that we shouldn't do that because then we get locked into another round. I think he made a mistake. Once he determined that we can pursue the declaratory relief and the declaratory relief with respect to the statute and the Constitution, the protonotary said that we had standing. And he says he doesn't very much disagree with that, but he's just going to leave it to see how the claim goes. And the protonotary said the federal court has jurisdiction. So I think on the pleading and the appeal, the plaintiffs definitely have public interest standing, and there's jurisdiction, and he's ruled that they can pursue the statutory and constitutional declaration. So he should only have struck the paragraphs dealing with the tort and damages and the charter claims and said, if you want to amend and come back with those, do it. If not, the action proceeds on the constitutional declarations. And so it's my view, and I guess we'll sit down and I'll get instructions, but talk to Anne. I think we should appeal on that narrow point, because if we win on that narrow point, then it just proceeds on the constitutional and statutory issues. And we can decide at that point whether we want to try to retwig the charter claims or if it's not worth our while, because we're really interested. What we're really interested in is the determination of the law and whether or not they can relinquish sovereignty in this way. All right? So I'm sure half of that is gibberish to you, but I'm happy to clarify it. Yeah.
3 points. Does it matter that Flaherty's dad and Mark Carney is now with the Bank of England? Second is, can you provide the highlights to Anne and Bill so that we could put it on the net so that our allies can know in general terms so that you don't jeopardize your case?
Yeah, I'll do that.
Because you're a bit of a celebrity on the net now because of your challenge on NATO and this legal challenge. There are people within our, I guess, subculture that know. And third point is, what resources do you need to proceed with the claim within the next 20 some odd days?
Well, I think I would lump in the appeal and the claim all in one. If the government appeals, which is highly likely, I'll just get the government lawyer to agree with me that the time be extended 60 days after the Court of Appeal ruling, so that we're not amending the claim twice. Because the Court of Appeal may disagree with the trial judge and say, no, they don't need to amend this, they can proceed on what's left. If they want to amend, fine, but if they want to proceed on what you left, just proceed. And so I don't want to have to re-amend twice. So you know, and do you want me to publicly set out what the fee is going to be for the appeal in either event plus the statement of claim? You're looking at all in with disbursements and HST $60,000. That's the fee to take it to the Court of Appeal and replead the statement of claim either after the Court of Appeal or before or both. That's what we're looking at, inclusive of disbursements and HST. You know, whether I have star status or not, I'm not getting the millions that the Hollywood stars are getting.
Rocco?
This is a lot of work. You have to appreciate it. This is where you've been to. You went to. I see many of the faces here were in court. You see the prep and the documents that necessary and the argument that it takes. Yes.
As a layperson, and this may not be particularly pertinent, but I've always wondered when the Bank of Canada Act says that the loans made have to be amortizable. Why would they say that if they weren't intended to be made?
Well, they wouldn't. Of course they're made. Of course, I mean, but we argued that. I mean, if you look at the structure of the, this is why he accepted my argument that it's not so simple that just because it says may, it's there. There's, if you recall, in law, I argued before both levels of court that there are 3 different meanings to may. One means you have unbridled discretion subject to constitutional norms, and the second most common meaning is you have the authority to do so. It doesn't mean you have unbridled discretion. That's what the may means in there. Because if you look at the rest of the structure of the Act, the may only means that the bank has the power to do so. It doesn't mean it can refuse arbitrarily because it says may. That's just whim. And so he basically, he didn't accept the argument as a conclusion at the end of the day, but he said, well, yeah, that's a serious issue that you can only decide on evidence, looking at the history and the full context of the act. But I agree with you, of course. That's why the may confers a power. It doesn't confer a discretion. Yeah.
Rocco, what kind of a time frame are we looking on for the next round of court hearings?
The Court of Appeal is fairly quick. We could be done and heard shortly before or shortly after Christmas. It's 30 days for the notice, 30 days for the agreement on what to put in the appeal book. There's not going to be any dispute here because it's a legal argument in the appeal. And then 30 days to put in the argument. I would speed those along because I don't need 30 days, 30 days, 30 days. And then we set it down for hearing. So if it's set down for hearing by July, August, we could get heard December, January by the Court of Appeal. And just to let you know, the Court of Appeal is the court just before the Supreme Court of Canada. So that's almost, it's a second last stop. Yeah.
And should we win this case, the implications to the government would be?
Well, I mean, the issues in this case really are no different than the issues in the Maidan reference and the Senate reference. You can't just willy-nilly urinate on the Constitution. I mean, I know I'm on camera, but basically, you can't simply abdicate. You can't abdicate your statutory or your constitutional duty to govern. You can't, through executive action and secret proceedings by foreign actors, simply give away the store. I mean, it's the same issues, Lawrence, in terms of, the underlying, as the Supreme Court of Canada talks about, the underlying architecture to the Constitution. The executive has to act within a certain boundary of democratic constitutionalism and rule of law. That rule of law doesn't mean that, the government decides it's going to do what it wants to do, without regard to the statute or the Constitution or the history, with respect to those rights and those duties. So.
Sorry, I was late coming in here.
Me too.
Congratulations. With respect to CETA, what is the impact of CETA on this particular, the financial part of CETA and its impact?
Well, I've been waiting. The government promised, and I'm going to talk about that too, Anne, about the challenge to CETA that's going to be coming. We've been waiting on the government promise to release the text shortly after Christmas. We're still waiting. The European Parliament has indicated that it'll take about 2 years before they approve CETA, and in Europe, like in the States, no treaty like that can go through without the Parliament approving it. So I'm waiting to see what provisions in CETA were finally agreed to. I've seen.
Agreed in principle, you mean?
No, agreed. There's a text that said that the Council of Canadians did an access for the text and it was denied. They should be releasing the text. One of the things we're going to, without putting it through Parliament, and so, but I like to see the text because it make the arguments more concrete. But if they don't release the text, we're still going to go into court saying they can't sign the text. It's not pre-released before they bind the country. And so I don't know what the final provisions are in CETA with respect to the financial institutions. I know that the Europeans were demanding that we get rid of our Bank of Canada, but they didn't prevail on that. So it's not in there, but I don't know how they finesse the financial services. There is some early drafts in November of the text. I don't know how authentic they are online. You've probably seen them online on a couple of websites. But if we don't get, the government doesn't release the text within, by mid to late summer, we're just going to proceed anyway.
Did the BIS in 1974 do anything illegal by stopping us from using our Bank of Canada?
Well, they're not bound by our laws. So I don't know that they did anything illegal. They're simply
Well, I
not.
guess the question is was it legally done and executed?
Well, as far as we're concerned, no, because Canada relinquished sovereignty by allowing them to do that. By being bound to their rules and their secret proceedings and their policies and their mandate and their marching orders, you know, our public bank basically.
Canada was illegal, not the BIS.
Yeah. Okay, Anthony? Yeah.
Yes, I'd like to just refer to page 48, paragraph 77.
I'm sorry, page 48?
48, 77, the tort claims.
That's not fair, you're actually reading it. All right.
I've got my glasses on. And just in the claim, you prepare a simple map to describe the presence of malfeasance, and the tort aspects you put down to simple figures. It's generally well accepted that tort does go on, and we have fairly prominent speakers, including Larry Summers, talking about how much that actually costs, and the competition of getting rent from different countries, which is what this is all about.
Yeah.
So, although he's thrown that part out, are you allowed to keep it if you present some?
No, he struck it without prejudice. I can replete it.
You can repeat.
Oh, yeah, no. He's thrown nothing out terminally. Okay, which is another win from the decision down below, because
Right.
he threw out everything terminally. No, but just to be clear on the tort, right? His striking of the tort does not strike our ability to seek the declaration that the way they present the budget is unconstitutional. That's it.
Yes.
That's it.
Okay.
Understand the difference?
Yes.
The tort means we can collect damages of $1 per Canadian, but you know, he has not thrown out our ability to pursue the declaratory relief.
Okay.
That the way they present the budget is contrary to the constitutional history and specific provisions of 53, 54, and 90 of the Constitution Act. Okay? Yeah?
If the Canadian government keeps appealing, isn't Comer up against the taxpayer?
Well, in a sense,
will Comer not run out of money?
Comer's coming up, is up against itself, yeah. In a financial sense, like I was on the NADOM reference, you know, I footed the bill myself. I didn't get costs from in the court. I had to put out all the costs myself, yeah.
Yeah, but is there any limit to, like, is there a point where they can't appeal
No.
and you win?
Well, yeah, the Supreme Court.
It's which?
The Supreme Court. They can appeal to the Court of Appeal.
Yeah.
And then if they appeal and lose on the fact that we can pursue these declarations, then they have to seek permission from the Supreme Court. And if they don't get it, then we start putting in the evidence and go to trial. Yeah. But make no mistake about it, most of these cases get killed at this level by being struck. So we've got the upper hand at this point in the sense that our major relief was declared to be pursuable. Okay.
And they can still appeal.
Yeah, they can appeal. Yeah, they can appeal. But I feel more comfortable with this decision in my pocket on going on appeal, if they appeal.
In terms of providing a specific deterrent to future parliaments and governments, certainly would you agree with the statement that a victory here would provide value for all Canadians?
I certainly am, for sure. I mean, this judgment in large part is already setting precedent in terms of jurisprudence. You know, if they appeal it and we defend it, the judgment itself, in many respects, is a breakthrough. Yeah.
So it could also be said that Comer is making legislation themselves.
I wouldn't go that far, but
in layman's terms, but by providing this specific deterrent, the future courts will be obliged to follow this decision.
Yeah, it's a break in this again in the same way that the judge's reference, the NADOM reference, and the Senate reference puts a limit on on government action by judicially circumscribing it and saying, no, you can do this, but you're going to have to account. If you do this, you're going to have to account at the statutory and constitutional level. Yeah.
This question, do you think the international bankers are scared?
I don't have any of them as friends, so it's hard to answer. I don't know. None of them.
You just said it might be a precedent, so
yeah.
Could this be a rallying cry for
well,
informed citizenry that realize
I can tell you I get emails and calls from all over the world on this case. I've had them from South Africa, Australia, New Zealand, France, Germany, England, the States. So yeah, people are watching, people are listening. We live in a different world now, yeah?
Do you think that will inspire cases in those countries that you just mentioned?
I have no idea. I think there's similar cases being pursued. I think it was in Holland, in Holland?
Yeah.
They're pursuing a similar case, yeah. Yeah.
I'm going to ask you, with regards to the common claim, could it become redundant if there's some passage of some acts at some level within Canada or within the global banking empire that would make all this a waste of time, because it would mean that the Canadian Bank of Canada doesn't exist anyway?
If the government abolished the Bank of Canada, that could and would happen. My view of it is, if the Europeans couldn't convince the government to abolish the Bank of Canada, it's not going to happen. I think that's people underestimate that kind of move in terms of the electorate. It'd be like abolishing CBC or universal health care in one swoop. I don't see it. I don't see it happening.
Good.
Yeah. I may be wrong. I've been wrong before. My mother used to tell me all the time I was always wrong. You know?
Wouldn't most of the lawyers be on the side of the guys that are, like, I think you're an exception, but an awful lot of those guys want to worry about their future business, so they would tend to go with the right wing, so to speak, wouldn't they?
You know,
pro bono isn't a great amount of legal. You can't make a living.
I think most lawyers are like any other citizens. Fact of the matter is that, you know, I can't purport to speak for most lawyers. I know politicians always say most Canadians, the majority of Canadians, as if they know, right? But you know, most lawyers are like everybody else. They're either informed. And if they're informed, they have to be motivated by something that pees them off to act. Or they're indifferent, or they're ill-informed, or they're just lazy, right? I mean, that describes any citizen, right? Otherwise, you would have, you know, there are citizens, you're here, and then there are citizens who say, well, if it doesn't affect me personally, what do I care?
But now that they're forming armies, instead of, like, lawyers couldn't be incorporated before, but they can now. And now they've gone from being gangs to being armies. And they're even switching identities back and forth as corporations. The motivation...
Who's switching back and forth?
I'm sorry?
Who's switching back and forth?
The lawyers... like, remember, it used to be that they couldn't be incorporated.
Yeah,
now we're seeing that they can be
incorporated. Yeah, but you should be careful. Lawyers incorporating, all professionals who incorporate are not like other incorporations. In Ontario, the person who allowed lawyers to incorporate was Jim Flaherty when he was finance minister.
Well, this was before.
No. It's Jim Flaherty. It's Jim Flaherty in Ontario, and because he recognized that, like other business people who were self-employed, who were running mom-and-pop shops, there was some measure of income splitting, tax benefits with one spouse at home. The big firms are not incorporated because there's no tax benefit to incorporating. Incorporating of a law practice only benefits the small guy. Okay? But even if you're incorporated, you're still personally on the hook for anything you do for your client. So if I'm negligent, the fact that I'm incorporated, but I'm still personally liable. So you don't get any of the benefits of being protected from personal liability. It was simply a tax measure that Jim Flaherty put in when he was provincial finance minister to allow the small sole practitioners, of which he was one when he was practicing, to be able to properly plan, because you know, if you're a small practitioner like I am, and let's say my spouse is at home with 2 kids, and I'm the only one working, well then, you know, it's like running a business, and you don't get the benefit of any income splitting. So, for instance, the shareholders in a lawyer's corporation have to be lawyers, so you can't put your kids or anybody else. So it's very limited, and it only benefits the smaller lawyer who has a small operation. And, you know, so the big firms, if you ever see, they're LLPs, limited liability partnerships. None of them incorporate. Because the only benefit to incorporation is that if after you pay your corporate taxes under the law firm, if you have any excess capital, instead of dishing it out to yourself as a dividend on which you pay more taxes, you can up to $200,000 a year. You can spend it on capital acquisition, which allowed small lawyers to buy their own office space, because a lot of them would be put out of business when the rents went skyrocket downtown. So that's all that was about. So I don't know if you're reading about American lawyers being incorporated. I don't know, because I don't know what the situation is down there. But I can tell you in Ontario, that's what it is.
But I heard it said that the Law Society is self-regulating in Ontario, and that makes me think that if the lawyers are about getting around all the rules and regulations, are we in trouble? You know, when the whole lawyer business can be self-regulating, something's wrong.
Well, I agree with you. I agree with you. But all professions are self-regulating. I've got a case that went to the Supreme Court that I'm going back up pro bono with one of my partners. The judges are self-regulating. I think that's wrong. Canadian Judicial Council. I think I agree with you. It's wrong.
Yeah, any corporation on earth.
Police self-regulating themselves is wrong. I agree. I don't disagree. But that's not restricted to lawyers. Our society is corrupt in that way right across the board.
Yeah, we saw Joe Oliver give self-regulation to the financial business across Canada.
I'm not here to talk about self-regulation. I've been indulging you, but I'm you know. Yeah. I got my own complaints too. Everybody complains, right? I got my own beefs. Next, John.
First of all, congratulations.
On all your successes.
I was interested in your saying that you were getting lots of messages from overseas and so on. Are these coming from private people that are just interested, or are they governmental or Kohler-like organizations?
And how many of them are death threats?
No. I'm not, oddly enough, no. Over half of them are from lawyers and professors. A lot, and about 35% are from what I can gather private citizens. So obviously well-informed, educated, but I can't gather what they do. But the ones that are clear are lawyers and professors.
Yeah.
Are you getting any inquiries from the legal societies here in Toronto?
No.
That's really interesting. No. Is there anything we can do to make that happen?
Well, let me backtrack. I went to my law school reunion, and there was a really good friend of mine who was there who started off as a carpenter in life and went to law school. So we got along, both working class, right? And he took me aside and he said to me, listen, my wife showed me these 2 statements of claim that you filed in the federal court. One with the Bank of Canada and one with the natural health food products. It's another case that I'm doing. I won't bore you with that. But anyway, they're very similar issues in terms of the health ministry just running roughshod over natural health products, right? And he said to me, she asked me, because she's not a lawyer, but she's very interested in banking issues and natural health food stuff. She said, do these things hold any water? And I said, well, what did you tell her? He whispered to me, I didn't tell her anything. I said, I'd study it. I said, well, did you study? He said, no. I knew we were going to have a reunion, and I asked you, what the hell is this about? He's been practicing 25 years.
Well, this worries me.
Okay. Well, worries me too. Worries me more, because you know, for instance, in the Nadon reference, in the judge's reference, you know, the Quebec Bar Association took no position. Well, that's startling.
Yeah.
You know, I actually, the Quebec government, the Attorney General, didn't come in until 4 weeks after we initiated our proceedings. It was touch and go. It was touch and go whether or not they were even going to intervene at the Supreme Court. So, you know, that's all concerning rather. So,
Greed or fear?
a bit of both.
Complacency?
Indifference, yeah. It's hard to say. There's 375,000 lawyers in the country. You know, what I can tell you though, what saddened me, I was in Karachi when the Supreme Court decision came down on the judge's reference, on the Supreme Court reference. I had 127 emails, and I remember the number because, you know, although Karachi is the 4th largest city in the world with 25 or 26 million people, you know, the internet goes something like this. You know, you get on finally, and you get disconnected. You get on, the power goes off. So it took me about 6 hours to clear those 127 messages. Of the 127 messages, all of them were from lawyers and law professors, all congratulating me. But only 6 said, we knew you could do it. All of the other ones said, we didn't think you had a friggin' prayer. So that tells you something about the profession too, right? If people don't take the time to study these issues, people just have a sort of gut reaction without informing themselves, which is, I'm going to say this without insulting anybody except ourselves. I think that's the typical Canadian attitude. I think that's a cultural malaise we have in this country. It's people tend to have this knee-jerk sort of, you know, basement Twitter, Facebook reaction to everything, right? They see a 4-liner, they decide that they can decide the issue, and then they pipe in. They just pipe in, you know? And I see this, I get stopped on the street. You know, somebody reads a newspaper article on a case I'm doing, and they say, you know, I disagree with you on that. And I say, based on what? Well, I read it in the paper. I said, why don't you go down to the courthouse, read the material, read it all, and then we can have a coffee in 2 weeks after you've read it, and then we can discuss it. I'm not going to sit here and discuss your understanding of a newspaper article on what this case is about. But that's how our culture works.
What, in the final analysis, if you're totally successful, what compulsion, what are you compelled to do on the issue?
I'm not going to speculate that far. If we're successful on the declaratory relief, and then there was a viable request for interest-free loans for a particular particular human expenditure program, then we could compel the government to extend that loan. Right? But you have to win the first battle first.
Yeah.
Or if on the amended claim we had a municipality coming on board saying, we asked, we were refused, we won.
That was good enough.
But that we can address behind closed doors and go there, because we had pleaded that with a few municipalities, so we could go down that road if and when we replead the claim.
Looks like you might be getting a lot of business if you're successful at this, to compel proper finance.
Well, I don't know about that.
Be nice, but
It'd be nice, but how many people, you know?
I'm willing to speculate.
No, I don't think so. You know, I think people, the court challenges, like anything else, are just part of the puzzle into, you know, part of the overall dynamics of forcing governments to be democratic and following constitutional, you know, agreements and you know, the social contract that we have as a nation. That's all. The rest really comes down to people like you who push for the government to do the right thing. And when they ignore, you have to, you have to push back in the courts. Oh, I'm sorry.
I was just going to ask you, do lawyers get get together and decide on common tactics. For instance, Clayton Ruby enforced ethics, or standalone.
No, and I want to talk about that. Unfortunately, we don't have a culture of that like they do in the States, and this is why 10 years ago I quietly set up something called the Constitutional Rights Center out of my office, and we've been quietly operating. I wanted to do it as a test run for a stretch, privately, quietly, to see how it worked. And we have a list of cases that a group of us who set up the center have litigated through the courts up into the Supreme Court and the Courts of Appeal. And with the reference, the NAGON reference, the Constitutional Rights Center was a co-applicant on the federal court application and was a respondent intervener at the Supreme Court of Canada. And so that's something that I'm going to be channeling a bit of energy into. I have a roster of a bunch of lawyers that I'm organizing to take on these public law issues, but we wanted to do a test run quietly to see how it would work. And now that we've done that, we're going to go public. We're mounting a website, and we've got the roster of lawyers. We're going to finalize the roster of lawyers, and we've got people lined up in three major cities so far. I think with the fourth, we've got the Toronto, Montreal, Vancouver, Winnipeg, and then we'll go from there. Unfortunately, unless a structure like that is set up, then you won't have the vehicle for that type of conferencing and communication between lawyers, because lawyers are busy like everybody else making a living. Something comes across their desk, sure, I get calls and I cooperate with others, I mentor lawyers, but we want to structure that into an institutional basis. So as modest as it is, then it'll carry on, and then we could fan out different cases to different lawyers of expertise and mount more cases. We've done a good, I think, 28 cases in the last 10 years. That doesn't sound like much, but these are all test cases. That's it's a fair amount. Unfortunately, the other centers that I'm not going to name them, and I don't want to besmirch them. The other centers that do exist are all publicly funded. And in my view, if you're going to fight the government, you have to be. Our mission statement says that we're as separate from government as matter is from anti-matter. We're not even getting we don't even have a charitable number. We refuse to, because anytime the government has a hook in you, you can't really fight the government.
That's right.
Yeah, I mean, let's be realistic. If they're controlling your salaries, then you're only going to go so far. So we want to be completely separate from government, and we are. But that takes the goodwill and pro bono, contribution of lawyers, and obviously we're going to fundraise and do other things. But without that kind of structure, then you don't get the benefit of collegial corroboration that allows, because one lawyer or two lawyers can't do it all. You have to fan out. And some of the cases come out of Vancouver or Winnipeg or Montreal, You have to be fanned out as well. Errol?
Rocco, on that particular Constitutional Rights Center, have you collaborated at all with Comic?
No, the only people I've collaborated with up to now are close associates and colleagues that I know have the gonads and the stamina. If they say to me, I'm going to do this, they do it. Once we fan out, then we're going to make new...
I think Democracy Watch could be now...
Sure.
Another point that I've been frustrated for years with government that not only abrogates responsibility but refuses to enforce legislation. I brought Kevin Page to Toronto last year to address his battle as parliamentary budget officer. And I am involved with a number of organizations that are totally frustrated with the government abrogating its responsibilities under the Canada Health Act, refusing to enforce the provisions of the Act with regard to the establishment, for example, of private clinics, committing just a fraction of what they did when the act was brought into power in terms of financial resources. And most recently, refusing to renew the Canada Health Accord, which provides for national standards across the country. Do you have any comments about this frustration of the government that will not enforce its own legislation?
Well, just a preliminary comment first, and then to the issue of comparable standards. When you said you were frustrated, I was glad that you quickly went to government and something else that we wouldn't have to turn off the cameras. But on the issue of national standards, I think it's completely challengeable. I think we live in a federation. Section 36 of the Constitution Act calls for transfer payments and equalization payments and conferences on that with a view to make sure that Canadian, I mean, it doesn't have to be completely matching, but you know, the issue of comparable levels of whatever service that the federal government is executing is a constitutional issue. In fact, that's one of the issues that we pleaded in the Comer case, which the Judge Russell recites as one of our challenges, saying that, you know, by not doing what they should be doing, this leads to regional disparities, which really is a breach of our right to a federalist state with comparable services at all levels. With respect to the other issue of private clinics, I guess that gets dragged in, but that's more of a micro issue, depending on which clinic you're talking about and which, you know, what the issue is there. But certainly on the broader issue of equal access to comparable levels of health care, that's a constitutional issue that the government can be brought to account.
That's under the Canada Health Act.
Yeah, yeah. And I mean, some of the challenges that I was pleading before Justice Russell were with respect to the Finley application, the other cases to do with the transfer payments for social services. Yeah. Is that it? Have I bored you enough?
Not bored.